Court will take the case of Equity Trust versus Riverplace Development. Mr. Tucker, it doesn't appear as though anybody wants to touch your case.
Well, unfortunately, you three would say.
Mr. Tucker and I have just reached agreement, Your Honors, that the fact patterns of the prior contract construction case are more interesting than an ours.
And that's maybe why we relaxed.
Good morning. I'm Bill Nussbaum, representing Equity Trust Company, Custodian for the benefit of Raymond Bro IRA, which was the contract purchaser of a unit in a high-rise condominium being constructed on the South Bank in Jacksonville.
Contrary to your pre-game comments there, I think it is a pretty interesting contract, and I know you were being humorous, but tell me why the partial certificate of occupancy did not meet the terms of the agreement as to requiring your client to close.
Well, that's the whole case. It really is. When you boil it down, Judge Thomas, that's the whole case. You've got one provision in the contract that says the issuance of a temporary or permanent CO constitutes substantial completion according to the plans and specifications, or words to that effect. But you
A
have
partial CO could never qualify under your argument.
Because I mean,
the contract says temporary or permanent. What they got was a partial. There was a comment, and it's in the transcript of the summary judgment hearing by counsel for Riverplace at the summary judgment hearing about one partial being a permanent, temporary, or permanent partial. Not to be confused with court comp cases. But that, of course, is not evidence. We really don't know what the requirements of the city of Jacksonville might have been for the issuance of any certificate of occupancy, because that's not in the record.
But this was a multi-unit development by council.
As the video discs, which are part of the record, show, Judge Lewis, this is a high-rise condominium. And this contract is for, as I recall, Unit 906, which one may reasonably infer, yes, is on the 9th floor or thereabouts of this development.
Is there any evidence for record that unit 906 was not ready for occupancy?
Now that's a good question. I like it, because the obligation of the defendant on its motion for summary judgment was to prove, at least this is the argument, that the unit was ready for occupancy. And the only thing in the record to support that argument is that a partial CO had issued on January 10th, some 2 weeks or so before the 2-year anniversary of the contract. But it was the defendant's motion for summary judgment, and therefore their burden to disprove what the complaint alleged was that the defendant, seller, failed to have the unit ready for occupancy within 2 years of the date of the contract, which was January 26, 2005. Now, please keep in mind that the video discs, which I would characterize as showing this area around the ground floor to be an ongoing heavy construction area, that video disc was taken some 10 weeks after the city of Jacksonville somehow saw fit to issue the CO.
But I mean, the contract says, construction of other improvements described in the declaration may be in progress. This will not relieve buyer from the obligation to close.
I recognize that, Judge Thomas, and once again, that's why we're here.
And you're saying that's a question of fact. I mean, how much construction, whether it's minor, major, maybe it's livable, unlivable?
You know, I think it's in my initial brief that certainly if the amenities weren't finished, the weight room wasn't done, the pool wasn't finished, the landscaping was being put in, that would be one thing. But as I look at that video disc, there's a lot more construction activities going on.
But your argument is really, if I may say, and I assume you'll disagree, but is your argument really not with the city of Jacksonville that issued the CO?
No.
I mean, they determined that the unit was habitable and you had a...
We don't know.
Now, I don't know why they did that. I don't know what they looked at, but they did it.
Neither do I. And we do not know sitting here today what the requirements are for the city of Jacksonville to have issued that CO.
But that's why the contract says the issuance of a permanent or temporary certificate of occupancy. And I mean, your argument has to come down, and correct me if I'm wrong, but your argument has to come down to the assertion that a partial certificate of occupancy is neither temporary or permanent.
I don't think so. Let's assume for the sake of argument that the contract said partial CO. All that would establish contractually is that the unit was completed according to the plans and specifications. But as I've mentioned in my brief, we don't know what those plans and specifications call for. Do they show plumbing fixtures, floor covering, window covering? Is electricity hooked up?
But that's getting into a punch list kind of argument, isn't it?
I don't think having bathtubs or lighting fixtures in your unit are punch list items.
But as I recall from your brief and the assertions, the main arguments, I mean, the main concerns of the affidavit were, I couldn't park and get access, which I think is not an insignificant argument on your behalf, but one of the buyers that did the affidavit, the wife, I believe, said that I fell in the parking lot, I could not park, I couldn't get access to the unit, essentially. Not, there's no bathtub in there, or I don't think the city should have issued the CO.
You're correct. She went on to say that the entire first floor of the building, including entryways, was still under construction of some sort, was full of construction operations and construction workers, was obviously a hard hat area, and was not ready for use by or safe for occupants.
But, and I'm sorry to ask so many questions, but essentially then your argument is, look, summary judgment was improvidently granted, so to speak. We're going to have a trial. You're going to, I assume, cross-examine the city officials, right? And say, how could you issue a CO? My client couldn't get to the I mean, how will a jury rule in your favor? Maybe I could phrase it that way.
A jury would rule in my favor by looking at the video discs on March 14th and say, there is no way that a condominium unit on the 9th floor in a high-rise was ready to be occupied by homeowners who must go shopping and carry groceries and park their cars somewhere in order to get to their unit. And please keep in mind that the contract in this case does require that the buyer have 2 parking spaces assigned to it.
Well, and really, there's nowhere in the contract that says final completion is the same as ready for occupancy, correct?
Thank you. That's the whole point, and that's the...
So this unit can be complete, but it's still not ready for occupancy because of the ownership interest that the buyer has in all the other property. In other words, the 2 parking spaces, the safe entry, the safe egress, those kinds of things.
Exactly, and this gets to the Kell versus Burris case cited in the brief, that it must be assumed that different meanings were intended by the use of different terms by the parties in the same contract. Completion according to the plans and specifications is not the same thing as ready for occupancy when you're talking about the unit on the 9th floor. And in prior arguments of this point, on which I have not prevailed, there are some cases that deal with a similar situation in a subdivision. I respectfully submit to you that a subdivision is different. You can drive your car through or down a street that's perhaps full or sort of full of construction operations, putting up stop signs, lighting, landscaping, whatever. But when you get to your when you get to your own driveway, you've reached your safe place to unload your groceries, unload your kids, and get inside.
Well, counsel, if we were provided that, the contributing date was the issuance of the certificate of occupancy, and if one has been issued, then why is that not inclusive of everything in this discussion?
Because
And when your argument be, I guess, the city of Jacksonville, would you notice as opposed to the applicant?
I'm sorry.
Would your argument be with the city of Jacksonville as opposed to with the argument regarding other?
But the city of Jacksonville doesn't have my client's $107,000. And the contract says it's got to be ready for occupancy. And Mr. Seller, I can't expect to be allowing my kids to go to school and come home and walk through this sort of area. I can't expect to go to the grocery store and have to park blocks away and walk through this sort of area to get up into my unit. It is not ready for occupancy. I don't care. Again, I don't know what the city of Jacksonville's requirements are vis-a-vis ongoing construction on the ground floor. I'll just leave it at that. But my interpretation of my contract is when that activity is as intense as it was, my unit is not ready for me to live in.
Let me ask you about your point number 2 real quick before we run out of time. But how are your damages limited?
Well, they must have intended to limit them somehow because they used the word.
So any monetary damages award shall be limited, and because they put that clause in there, then it makes everything else.
No, as I pointed out in my brief, Judge Hawks, I think that clause would, in a market that was totally different than what we've got today, if prices were rising and the seller decided to breach and sell to somebody else for a greater price, then obviously we would not be entitled to the benefit of the bargain damages in a suit against the seller. I'd like to reserve, I thought I was going to be real brief. Thank you for all your questions. I'd like to reserve the rest of my time for rebuttal.
Okay. So is a partial the same as a permanent or a temporary?
Yes, I've got, and it was in the record at page 131, a certified copy of the City of Jacksonville Certificate of Occupancy, and it's got several different boxes that can be checked, and one of which is partial, one is temporary, and one is just the final certificate of occupancy. And the difference really is, are you talking about a portion of the premises, or are you talking about a time period?
So your contract makes reference to 2 of the boxes that could have been checked, but it doesn't make reference to the box that was checked. And we're to assume that it doesn't matter which box was checked.
I think
you had 2 out of the 3 in your contract, but the fact that the city picked the 3rd doesn't matter to our analysis.
This is I think that the court, in accordance with all the case law out there, has to take a reasonable construction of the contract as a whole. And I'm going to go through some of that with you. But when you're talking about a partial certificate of occupancy, it is a complete a certificate of occupancy as to those levels. In fact, in this one it says that the certificate of occupancy for levels 4 through 14. This was a 24 story building.
And we're to, and then the other aspect, of course, is that the certificate of occupancy equals ready to occupy.
Yes, yes.
Final completion, I guess final completion is the same as ready to occupy.
Yes.
Well, actually, it was ready completion according to the plans and specification, which that unit could in fact, would you concede that that unit could in fact be complete? It could have the decorations on the walls, it could have the furniture in there, it could have the bathtub, it could have everything, but be completely inaccessible and therefore not ready for occupancy.
Well,
is that true?
No, then this document would not have issued by the city of Jacksonville. This document is by the city of Jacksonville says it is in fact, it says this certificate authorizes the portion of the building described below to be occupied for the use specified prior to the completion of construction. And the part above where it talks about type of construction says residential. That is part of that. It's not in this record, but Mr. Nussbaum and I have several cases. He's taken the deposition of the man who issued that. It's not in this record, but what he says is that's exactly what this is all about.
Well, your argument, sticking to this record, essentially is that, let's say this, I think you can tell by my questions, I'm looking closely at that language, but she says you couldn't get through the first floor. Let's just take that at face value for the sake of argument.
Which don't we have to?
Your argument is that, that's right, your argument is that, well, that's your problem, but I've got this certificate that says you can go up to the 9th floor. Is her remedy then to sue your client for trespass and say, you have to give me access to my own unit?
Well, first of all, her affidavit doesn't say that she didn't have access. In fact, her affidavit reflects that she walked entirely through the premises. The only thing she says she couldn't get to, she says, is I couldn't, my parking spot, there was something in it. She hadn't closed. Until she had closed, my clients, who are the contractor, who are the developer, are using that for construction purposes. There are other people living in there then. If she had closed, her parking spaces would have been made available to her. If you look at the tape that she did, the video, none of it has to do with her apartment or her unit. It's all everything else. It's all outside.
So council, parking spaces were not made available to her. Her remedy would be to close and then sue you.
Her remedy, well, first of all, there's nothing in the record that says her parking spaces would not be available for her at closing. That's when we're supposed to deliver custody of it. There was no question that they were built. The question, she's suggesting somehow that because somebody was using them on the day that I came by there to inspect for this 1 hour period, that somehow means that they have not completed. The completion is correct. What
is that assertion in the record? Did you counter her assertion that she couldn't get to her parking spots in the motion for summary judgment?
No, we didn't. There was nothing other than the affidavit by the developer that it was completed and that the certificate of occupancy was provided. But what the contract, it's not ambiguous. As Judge Cole, when she looked at the entire contract and not just portions of it, she recognized that this contract recognizes the way in which this project was going to be built.
Well, let me ask you about that, because I think, and correct me if I'm wrong, you're going to talk about, we envisioned that there might still be some construction at closing.
It's not that we envisioned it. We knew that it was going to happen. We identified it in about 3 different places.
But it says
in the contract.
It says that there may be construction. Correct.
It says that, but there's several places that Mr. Nussbaum is not pointing out.
Is there any limit to how much construction can be going on?
Would there be any limit? The limit is...
is there any reasonable point where if the construction level passes this point, then realistically the unit is not ready for occupancy?
If you look at the 20th East 74th Street case that was cited by Judge Cole, in that case the developer and the buyer did exactly what was done here, which was they used the certificate of occupancy to determine when the buyer had an obligation to close, when it was complete. And what the court recognized there is they said, look, ordinarily you're going to have affidavits about at what stage the wallpaper isn't up. You've got to do punch list things, as somebody said earlier. What these parties have done is they have picked a bright line test, something where there can be no argument, where you've got an objective third party who is looking after the certificate of occupancy is based upon the safety for use of that building for that purpose. and they've identified a bright line test.
Well, now, if you go to the bright line, then in fact, that's not the bright line that was established in the contract. That's close to the bright line, but it's not really the bright line.
Well, let me see if I can help convince you that it was, because I think if you look at the four corners of the complaint, again, when you look at paragraph 4, which is construction, it says the buyer's going to look at the plans and specifications, so he understands the project. This is a 24-story tower. It's got adjoining townhomes and retail space. It's going to be constructed in a progression stage. This is not a situation where everything is going to be finished exactly at the same time so that everybody can move in at the same time. That's part of how a developer finances it or figures out how he's going to make his money. Otherwise, you're going to have to wait until the whole thing is done, and you're going to lose some of your time, value, and money. The contract specifically references that. It says in paragraph 4, after talking about the plans and specifications, says the issuance of the temporary or permanent certificate of occupancy from the applicable government authority shall constitute final completion and compliance with the plans and specifications. Then it goes on, and it could not be clearer. It is contemplated and understood by the buyer that at the time of and following closing, construction of other improvements described in the declaration may be in progress. Maybe this might have been the penthouse. This might have been the last one they were working their way up. This might have been the last one. So it has to be maybe. Not going to always, but it's certainly contemplating and putting the buyer on notice of that. And it says, this will not relieve the buyer from the obligation to close at the time provided for. That could not be clear. We could not draft it. But if there was anything, we had to make it clear. We went on in paragraph 7 for the punch list. It talks about the punch list. It says, seller shall be obligated to correct the same at its cost. And then it says, within a reasonable time period after closing. However, seller's obligation to correct same shall not be a ground for deferring the closing nor imposing any conditions.
Counsel, I noticed in the opposing party's brief at page 11, counsel said if the seller had wished for the construction given by the trial court, it could have used the language quoted in Fernandez versus Homestar Miller Cove, Inc., quote, the issuance of a certificate of occupancy for the residence or other such similar certification, etc., will conclusively establish completion of the residence and purchaser's unconditional obligation to close.
Right.
That would have been preferable, right?
That would have been clear.
That would have been preferable, obviously. But Judge Cole, in rendering her decision, recognized the Fernandez case. In fact, she used it. And she said that just like in Fernandez, you have to look at the various provisions as a whole and determine whether or not it as a whole does it make sense.
So does your argument hinge on the phrase that I quoted earlier and you quoted, a partial or temporary certificate of occupancy shall constitute final compliance?
Not only on that, it's that is obviously probably the key one. The second one is what I read about the punch list. You've also got a paragraph 9 for the closing. If the closing date is based upon the completion of the unit, which this one was, then you give notice. So it says closing is based upon the completion of the unit. Then if you go and you look at paragraphs 13 and 14, they talk about right of access and obstruction. They again recognize that, look, you may move in, there's going to be other stuff going on, and as a result, you've got to allow us to do these things. And then you get to, if I can finish, Judge, if you get to paragraph 18, which is the one he says, like, throw all that other language out. Let's just look at 18 myopically. Paragraph 18 is entitled completion date. Completion date. That language has to refer back to the completion that we've been talking about in the closing section, paragraph 9, and in paragraph 4 where they talked about the certificate of occupancy. And they're talking about the unit. Now, they've got in here where they talk about ready for occupancy, which kind of bleeds us over a little bit into the other argument, which is the ILSA, the Interstate Land Sales Act. This, if you didn't even have this paragraph 9, this paragraph 18 that says completion date in there, if you didn't have that in there at all, the closing would work just like clockwork. Everything follows along perfectly. This provision probably is in there to satisfy the ILSA requirement. The ILSA requirement is that you got to get it done 2 years. And if you look at the HUD guidelines that kind of backstop the ILSA statute, it talks about ready for occupancy. That's one of the things that they talk about meaning as complete for purposes of the 2-year obligation.
What does any monetary damages award shall be limited mean?
what it means is it's a recitation of what the law is. It's basically, it's going to avoid things like punitive damages, but it's certainly consistent. I mean, it's not, when we cited, I think it was the Moses versus the Antiono case, an old Florida Supreme Court case, that said those very language that was used, direct and proximately caused, are the very types of language that define what damages are recoverable, including special damages. So this provision in there with a limitation, if it calls a limitation, is really an acknowledgement that in fact the type of damages that are necessary to maintain the LLC exemption are put in there. They're put in there. They are consistent with the Hardwick case, and they are consistent with the Samara case.
Well, again, wouldn't it be a better if it said buyer's remedy shall also include the right to maintain an action for monetary damages, period, instead of comma, provided however?
Provided, however, that they have to be direct, they have to be approximately caused. That's a surplusage.
Doesn't always have to be that. I mean,
it's surplusage, but it's making sure that everybody understands that, for example, we don't have an argument down the road of somebody saying, hey, look, I didn't close them, but I think I probably could have gotten somebody to buy it, and I think it might have been this. All this is saying, all this language is saying is, look, we're going to let you have your money damages. There's no question about it. But they've got to be money damages as would be permitted under the law.
it doesn't say that. It says they're limited.
No, but it says limited, but then you go on and read what it is. The language, they say that the damages that are allowed.
So it's your argument that the ILSA claim that your opponent is raising would only apply if the contract, like the other case, had said your only remedy is specific performance.
Right.
So your only remedy is to get your refund.
Well, doesn't this really say, though, I mean, couldn't a reading be put on this that your monetary damages are limited to a return of the deposit paid by the buyer with interest? That's our max. And provable. In other words, up to that cap, you prove your damages, and that's the cap. I mean,
It doesn't say that.
It says and. It says
And.
that any monetary damages shall be limited to the return of the deposit paid. So it has to be deposit paid,
Sure.
and that which you can prove are your actual out-of-pocket damages. I mean, why is that?
It doesn't say.
This is and.
It doesn't say actual
This says
out-of-pocket.
and provable actual monetary damages directly and approximately incurred. So it has to meet both conditions, and so to meet both conditions, isn't it the cap, and that would violate the case law, and then make it as violative of it. So
No, it's the use of the word and. It doesn't say you get your deposit back only if they also, are in this category. The and is you get both of them. It's a conjunctive. And if you look at the case, the Moses versus Otano case, it's a Supreme Court case from 1908, still good law. It says, under a general allegation of damages in an action on a contract, such damages the law holds to be direct, natural, and necessary result of the breach complaint may be recovered. Special damages are those that do not necessarily, but do directly, naturally, and proximately result from the breach and may be recovered in proper cases. This language is not limiting. The only thing that it may be limited is punitive damages, which the cases that have addressed this clearly say is not, that you can do that and still not have it being illusory. What this language is not a limitation. It is a confirmation that these damages are allowed, but only those and not others. And that confirmation of what damages are allowed is exactly what the law already provides. So there's no limitation. Mr. Nussbaum can't stand up here and say, other than punitive damages, what his client was limited from getting. He can get special damages, he can get consequential damages, he can get whatever.
And the conjunction doesn't mean your return of the deposit to the extent that it's provable actual monetary.
No, it doesn't, Judge Watson. I'll tell you that Mr. Nussbaum and I have argued about this end to this end on that contract. And he has not once, and even in his brief, he doesn't make that argument. That is not the interpretation that anybody prior to today has made. And I would suggest to the court that that is not the plain meaning of the language that was used in the contract. For those reasons, we ask that you affirm the decision below. Thank you. Thank you.
John, I take it back. I think they found this interesting. Reading, forgive me, consider this far from fanciful scenario. Seller finally has the unit ready for occupancy 30 months after the contract was signed. By then, interest rates have increased, and the buyers have lost their favorable interest rate lock. But they've got to close on the unit because they are contractually obligated to move from the home that they live in. They do not have the time or money to fight the developer to get a deposit back and find a replacement home. They got to close. If they are lucky enough, they might be able to preserve the right to sue for damages. Can you hear the seller saying that the increased cost of financing was not, quote, provable actual monetary damages directly and proximately incurred as a result solely of this transaction? I can hear him saying that. As to the, getting back to point one of the brief, I just do not see how any reasonable construction of this contract using different terms in different places could be held to require the purchaser of a residence on the 9th floor of this unit to consider his unit ready for occupancy under the circumstances which exist as clearly shown by Mrs. Bro's affidavit and at least video disc number 1. I think there was enough there to create an issue of fact that ought to be determined only by the trier of fact and not on summary judgment. We urge you to reverse. Thank you.
That concludes our document for today, and we'll be in recess until 9 o'clock tomorrow morning. Thank you.